Thank you for listening to The Pain of the Claim, your source for prescription strength claim relief. And now, your hosts, Jeremy and Donna Lavelle.
Hey, it's Jeremy with Remedy Claims here. I've got the awesome opportunity to sit down and talk with who's become a really good friend of mine, Scott Hunziker. He has provided so much counsel and direction. The guy just blows my mind every time I talk to him. Hey, Scott, thanks for coming on the show. I really appreciate it.
Well, thank you for having me. I appreciate the opportunity.
I asked you before which law firm you work for, but I was about to get writer's cramp before I could get it all down. So I'm just going to go ahead and have you go ahead and tell us, what's the law firm that you work for? What city are you out of?
And we are hubbed in the Houston Galleria, right off Post Oak Boulevard, right near Williams Tower. As a company, we have offices in LA, Chicago, New York, DC, Dallas. We cover quite a swath, but that is our home office, so to speak, is in Houston.
And you primarily deal with what we know in the industry as bad faith claims. Is that correct?
Yeah, bad faith claims are an extension of the first party insurance practice. When people bring a case, it's because they have purchased a policy of insurance, which under Texas law is a contract. So when somebody doesn't fulfill their obligation, they breach the contract. Just like if you didn't pay your insurance premium, then you would breach it, and then you couldn't avail yourselves to the benefit of the contract, the insurance policy. The insurance company is also liable if they don't follow up and have your back if there's a loss. That is the what. The why and the how sort of gets into bad faith. When they do that, fail to stand beside you, stand behind you and fulfill their obligation in a set of circumstances that has no reasonable basis, where they don't have any good faith reason for doing it, then Texas law recognizes there can be some sharp penalties for that type of conduct. And we certainly look for those opportunities for our clients who have suffered those circumstances.
Well, I was just talking to one of the adjusters that works with me here at Remedy Claims just the other day, and we were going after some different strategies. And quite frankly, I just sent him something in our messaging service that basically details sort of what bad faith is. You know what I'm saying? And that's section 542.003 of the Texas Insurance Code statute, and it's titled Unfair Claims Settlement Practices Prohibited. Now, I think a lot of people make some mistakes on what they actually think bad faith is. Can you kind of give us an idea of what somebody might, like the insurance company denied my claim, so we automatically jump to bad faith? Is that always, that's not always true, or can you expand on that a little bit?
Yeah, and I think one of the best ways to do that is to talk about the causes of action you can bring within the first party context. So let's just start out with a very pedestrian set of circumstances here. Somebody that has a roof that is damaged after a windstorm or a severe hailstorm, and they have experienced damage that warrants a full replacement. And they believe that from the people they're relying on, that the roof should cost $29,000. And then the insurance company comes out and says, no, it's a small roof. I think this is worth $19,000. And then, minus the deductible of, say, the deductible is 1%, they pay $16,500. And you're saying, well, no, it should have been $26,500. That can be what you call a bona fide dispute, a good faith dispute, where both sides have a reason for what they're saying. Somebody may be wrong, but they're not getting to the wrong conclusion by doing something untoward or intentionally bad or malicious or vexatious in the decision to refuse the additional amount. So in that situation, you have a certain set of remedies that you can get. And in Texas, thank God, you can get your attorney's fees even without bad faith. You can get some prejudgment interest. You can get certain defined costs of court. Not every dime you have to spend, but certain things that are set forth under Texas law for recovery by the policyholder, by the plaintiff. And then, and here's sort of the next step is when you get over to 541, you got two statutes that apply. You got 541, you got 542. Now, 541 is the actual bad faith practices. 542 is the Prompt Payment of Claims Act. Okay. Now, let's take a step back and let's talk about these two things, and let's really talk about the purpose behind them. All right.
Okay.
Bad faith law exists because of an inherent disadvantage that a policyholder has in facing up against an insurance company, facing down that carrier that has all the power. They've authored the policy. Under law, you got to have the policy. They hold the cards. So when they are doing things that are specifically listed as inappropriate, they can get whapped in the face really hard with some of those laws and penalties that are allowed to a policyholder. I'm going to give you an example of something you can't do. You have three areas of coverage. You have, say, you've got coverage A for structure after a fire, coverage B for the contents inside the home, coverage C for alternate living expense for having to go get a reasonable hotel accommodation during the time that you're rebuilding. And let's say the insurance company knows right off the bat that they agree the thing is a full loss, but they're disagreeing over the value of contents, or they're disagreeing over what the ALE payment should be. They cannot hold up your first payment on the structure in order to force you to give up your rights on the other two. See, that's an example of dirty pool. You can't do that. All right.
Okay.
In that situation, you could claim bad faith, and you would have an opportunity in Texas to get additional penalties. You can get a lot more of a recovery than you can in other states. Now let's go on over to 542. All right. 542 is not about necessarily intentional malfeasance, bad faith conduct, untoward actions by an insurance carrier. What 542 is about, it recognizes that they have to do things within a certain period of time, whether they get the right decision or not. Here's an example. They've got to, within, I believe it's 15 days. I always go back, and I should have reread 542 before I walked in here with you, Jeremy. But you've got to at least accept or deny the claim within a certain period of time, and
15
ask
days.
If you need, you need to also ask if there are any other information you need, any other documentation, any other materials that you need to reasonably evaluate the claim. Now, this where things get interesting, because I'm going to use this example. We're going to carry it out a little bit. If somebody's claiming lost profits from a business, then they may have to turn over, obviously, profit and loss statements, tax information, things like that. But if they're not, and they're just claiming, let's say they're claiming personal belongings. Well, an insurance company can't say, for instance, well, I reasonably need to see all your tax information. No, you don't. He's not claiming that. So just because it lets you, Mr. Carrier, ask for all this additional information, it still must be reasonable in its scope, reasonable in its nature. When you don't do that, then you can be in violation of 541 if it turns out that it's completely without reason or justification. Now, on 542, let's say that they go ahead and they do make the right decision, but they take too long to do it. They can have specific penalty interest apply. I think now it's 10%. It used to be 18. The law changed in 2017 that in my opinion, removes some of the teeth out of the remedies that are available to a policyholder. But you can get additional penalties and an additional recovery, because even if they get the right answer, if it takes them an extra 6 months to do it, well, you are out the money. They shouldn't get the benefit of the float, the interest on the money that stays in their coffers, where it looks a lot better to them than it does in your hands. So right. These are things in 542 that's based on the amount of time it takes them to do what they need to do. And then because you have 60 days to pay it, for everybody that gets denied, and then it turns out they should have been paid, then it's not just a breach of contract, but it's also a breach of that provision automatically. And then the question becomes, was there a bad faith reason for it? Not just a wrong decision, but an unreasonable way to arrive at that conclusion. So those are the differences. You've got breach of contract is the general construct for the whole thing. It's sort of the platform. And then 541 is if there's bad faith for that breach. And 542 is maybe there's not bad faith, but a delay nonetheless and remedies that attach.
So can a bad faith accusation be levied by a homeowner is my question. How are they to know? So the first thing that they're going to do is either call a public adjuster or an attorney. And in the state of Texas, you're well aware that the knowledge of public adjusters at a consumer level or is not as well known. We're not that well advertised. You don't see any commercials on televisions like you would like personal injury attorneys or things like that. And so the first thing that what they know to do when an insurance company is involved, obviously, is to call an attorney. That's the first thing that they want to do. And because what I find is there is no executive branch when there is a wrong that is handed down, because you can say things. Let's go back to the pertinent document thing. The policy clearly states that we are to release any and all pertinent documents, and it's all in their right to access and all of that. And all of that. The question becomes is who gets to determine the definition of pertinent when it's not listed in the definitions of the contract? How do we fight? How does an insured or a PA fight a tortured interpretation of the policy?
Okay. And, I've always said, what's the old adage that information is power? You want to arm yourself. Knowledge is power. You want to make sure you have be as circumspect and as hungry for that type of knowledge as you can be, before a storm arrives. Build the ark before the flood, so to speak.
Yeah.
And this is what, before people need to be calling PAs and lawyers, I think one thing that, a lot of people don't do is they don't reach out to their agent and say, hey, I placed this through you. I need you to explain to me, we're getting toward the season here for, let's say it's, winters, you got freeze damage, spring, you've got, typically you'll have hail, tornado stuff, and that's into the summer, you got fires. Then you've got, hurricane season when you get to August, September. Year round is, sort of a carousel of different perils. So there's never a bad time to get with your agent and just say, listen, I want to know what my rights and responsibilities are here. And what can happen if I don't know what this means? You need to be reaching out to your agent. And here's the other thing. You need to say especially if you're a business person, you need to be saying, what kind of coverage do I have? Do I have, coverage for a lapse of my profits, on a monthly basis? How many months does this go? You need to know what you have available to you in the event that you do suffer that type of loss. And these things wrap right into your questions about, what does this mean I'm entitled to? Can I, a lot of people right now, you and I'd spoken about this, Jeremy, get denied a simple request for a certified copy of their policy. And that's the policy you own. Explain that to me.
It's something you bought and paid for.
Well, and the thing is, if you can't get a certified copy, then if you don't have the right copy, that'll be used against you when you get in the litigation. If you get in the litigation that's not the right copy. Aren't you entitled to see what your coverage is? Aren't you entitled to see if it's had things added to it? Aren't you entitled to see if, beyond everything else, the policy they have in your file is the same as they gave you to keep in your file? We should be allowed to do a little bit of A/B testing between what they say you got and what you actually got.
Yeah, I call that the good old fashioned Pepsi challenge. Let's put
these two up. That's a Pepsi challenge on that.
Yeah, right. I'm showing my age there for sure, because I don't think we've seen the Pepsi challenge since the '84 Olympics.
Listen, I'm going to tell you something, and you're not going to believe it, but I've known you a while, and it's true. I for a second there, before I said good old fashioned A/B testing, I almost said you need to take the Pepsi challenge between what they got and what you got. Man, you and I even remember that new Formula Coke back in the 80s.
Right.
My God.
What was that? Anyway, yeah. That's another podcast altogether. And we'll have to look at that one and take the Nestea plunge on that one later. So
that's what I was going to say. There you go. See, we can do it all day, folks.
Yeah. I got thousands.
Us Gen Xers, we've got all kinds of reference points. We've got all kinds of them.
I can go all night.
That's the way to do it.
So, Well, I mean, that's where I really find that when it's not so much the language of the policy that's difficult. The biggest issue is the interpretation of the policy. And I don't care what you're reading, where you're at, when there's no terms that are involved. I mean, I can get into things that the policy doesn't even address, whether it's general contractors overhead and profit. And I promise you, we wouldn't get into that because it's not really something to argue about.
Right.
In my opinion, it's very clear. But the hard thing is like when we feel an injustice or something's been wronged by us, who do we call? And it's like, I don't know what kind of response you've gotten from most of the governmental agencies that you've contacted, but it's not the utmost care that you receive in those situations.
Mm-hmm.
You know, and it's hard when you're in a situation and you're not even really aware because you could be wrong, but you can't know because there's just no explanation. And so you brought up the fact of an agent. Now, I am a big proponent of having a captive agent because you can go to insurance brokers and they may get you a great price on a premium. And there is nothing against the carriers that have decided to do the bulk of their business through brokers or whatever the case may be there. But I am a big fan of captive agents. And in fact, one of my favorite one just opened, has his, not just opened, but he's been an agent for a while for farmers. And I mean, they're one of the ones that I like right now. And he's a good agent. He's going to make sure he goes through everything with you. And the power of a good agent behind you is immeasurable. And I know that because they are on your side. They literally are. And they can be a very effective voice when it comes to talking with the claims department of any given carrier. And so it is an ally in these situations. And I'm going to tell you, if you have a claim, you need all of the allies that you can possibly get. When it comes to affecting what the nature of the policy is for. Because while we can get into the letter of the policy, we can also get into the spirit of the policy. What is the point of the whole thing, as opposed to getting away from it? And that's kind of the next thing that I want to get into. Do you find in your litigation proceedings that a good portion of the carriers are looking to simply deny claims? Because we know about the McKinsey report. Anybody that's been in the industry or has the time to sit down and watch something like that is probably aware of the McKinsey report that was done back in the late 80s, early 90s, that State Farm and Allstate both hired this firm to figure out how to maximize their profits. I understand that we're all in business to make money, and I'm not going to begrudge anybody for starting a business that makes money. But the issue is some of these practices really infringe upon the rights and what we thought we were paying for at the policy inception day. So, I mean, I guess what would be your advice to people, whether they're a contractor, a homeowner, a public adjuster? When do we start blowing the whistle?
Well, you mentioned the McKinsey report, okay, and I wish there's a few books I wish everybody would read. And one of them is a primer on the effect of that. I think it was 92, 93, maybe 94, this McKinsey report, where they were deciding that they were going to greatly broaden the way that insurance companies are going to profit. And they're going to do it through withholding a lot of those reserves that are set aside as their policyholders' money. That paradigm shifted after that McKinsey report, something fierce, you know, when Allstate commissioned that report. The book is Good Hands to Boxing Gloves, which is a fantastic book. I also, just to bring this full circle, dear friend of mine, David Skipton, wrote The Claims Game. And then one of the Bibles within the industry is Delay, Deny, Defend, which is an incredible book. I mean, these will explain what's going on here. Let's talk about it. I want you to imagine you've got a pie chart completely filled in. Okay, it's 100% filled in. All right. Well, insurance companies look at this pie chart and they're like, okay, here's this community, here's this population of claims that should be paid. All right. What would happen if we just said no to all of them? All right. Right now, if we paid dollar for dollar on 100 out of 100, we're paying $100. If we say no to all of them, and then only 12% of people even go to a lawyer, all right, let's extrapolate on this. So 12 people go to lawyer. Now they've already saved $88. And remember, if those 12 people end up getting all their fees and penalties and all this, at most, that's probably going to be 3 times or let's say $4 for every one of them instead of $1 on a payment. Well, you've still now gotten, instead of paying 100, you paid 48. So you're saving better than half. You're saving 52 of your dollars if you're the insurance industry. But let's take that 12. Now that 12, they go talk to a lawyer, and maybe they're trying to talk to a heart specialist about a broken foot. They just don't have the right kind of lawyer, right? So it doesn't go well. They end up in sort of this cul-de-sac situation where they never can get where they need to be. And 6 of those never pan out. Now we're down to 6 remaining. 5 of those find a good lawyer, but only 3 of them know how to try cases, and only 2 of them will. So basically, out of 100 people, only 2 have the ability to, even if they got 10 times damage, they're saving 80 cents on their dollar, with only 20 bucks paid out of the 100 that they would have previously paid 100. So here, you said, what can people do? Don't be part of the profit side of that equation. Go talk to somebody. Find out if they know what they're doing. Listen, I'm the first one to say, I'm not sitting here saying, I mean, you want to call me, you can call me. I'll give my number all day. It's on my business card. But just talk to somebody and ask them, listen, do you do broken limbs, or are you just a heart surgeon here? I mean, find out if you got the right guy, make sure they're honest about it, and explore your options if you've had a claim that you feel has been either incredibly delayed, underpaid, denied for no reason. I mean, remember, they're banking, the insurance industry is banking for good reason, with actuarial support. They are banking on a massive amount and proportion of these people not advancing on their claim. And then that money stays where it looks a whole lot better to the insurance company in their bank account versus your hands.
Right. Even if it's delayed on getting to your hand, even if you do go talk to somebody,
they get the float.
They can, they're floating all kinds of extra out of that.
Well,
and as it pertains to litigation, one might argue it's like, well, I need a roof next month. Do you know what I'm saying? I need a roof right now, and I don't have the 2 years to wait for it to come through litigation. What would you say to that person? I mean, how quickly does this process happen?
Well, it happens a lot. I'll tell you one thing the insurance industry does is they're getting a discount on what they have to pay, because you and I know here's the thing. If you are entitled to a element of your house, a roofing element, any part that needs to be replaced, and you're allowed the same quality, like, kind, and quality, and you know you're going to have to pay for not just the product, but also dedicated and qualified labor to do it right.
Yeah.
Then what do people typically do? They typically go out and they find, cheap labor. They get people that maybe aren't as qualified as others. Maybe they're not, anything. They're not bonded. They're not backed. They're not part of a legitimate company that does it with, an eye toward the industry standards. And you end up paying them a lot less because you're put in a tough financial position. Well, what you've done is you've just lessened the amount that the insurance company has to pay you back. So if your policy entitles you to a Mercedes, don't give them an excuse to only, give you a Kia. I mean, I'm not bad mouthing Kia. I'm just saying that
Kia's a fine automobile.
Fine automobile. It's outstanding, but it's still it's not the Mercedes. So don't give them a discount by having discount work done when you're entitled to do the job right, even if you have to pay for it up front, and then you get a dollar for dollar recovery because that's the policy you paid for.
So, I mean, I guess one of the things that I'm wanting to drive at here is that when you have a claim, you've sent in the claim, you've done everything that a good and prudent person would do to turn in the information. You've granted all the access that they need to come and discover what they discover, and then they turn around and they give you a denial, and they may cite something in the policy that states that we don't cover wear and tear. Do you understand what I'm saying? It's like, and I have seen this happen. I can't tell you how many times is that we don't cover wear and tear, or we don't cover mold. Your policy is a mold exclusion. And the average person doesn't understand, is like, yes, we understand that you don't cover wear and tear, but that's not what we're claiming. What we're claiming is storm damage or water damage or something like that. And this is an ensuing loss or an overlapping loss. And so interpreting some of that and how that works, they get it sent, they cite the policy, they improperly cite the policy. And how are they not held? How is that not fraudulent? I guess is my question.
Well, I think first of all, the short answer is many times it is fraudulent, because if you really follow their position to its logical conclusion, then no house could ever have coverage unless it had a loss the day after it was built. Because just like a human being, I've got wear and tear, I promise, on me. And once, especially down here in Texas with the elements, a property, whether it's residential or commercial, is going to have manifestations of wear and tear, after it's built, after a rainstorm, after whatever. I mean, after, shingles are baked in the sun in 112-degree heat. But unless you have a brand new building, insurance companies can say everything's wear and tear. And the reason it's so frustrating is because it literally allows that excuse to be used across the board. If you will not have damage to any part of a building that doesn't already have some wear and tear,
some use to it. Exactly.
Yeah. The thing is, these experience, the cycle of the seasons, these experience storms, weather. And this is what's so funny. Now, I want you to think about this. So you get a hurricane that comes through and hits Beaumont, Hurricane Rita, right? And let's say they say, no, there's just no storm damage from this. And, it's wear and tear. Well, then what happens is then when Ike comes through and devastates it, well, that was from previous storm damage. They want their cake and eat it too. And they talk out both sides of their mouth. And at the end of the day, the policyholders left holding the bag because they're not going to pay for it. And then everything they don't pay for now is an excuse for why they don't pay it later.
That's exactly my point. Therein lies my point, because I have had this argument. And in fact, I'm gonna paint a scenario that's completely hypothetical. Okay. And it's going to seem like a small thing, but as it pertains to, and I'm going to ask you as an attorney to answer a very simple question, but I want to hear the legal answer to this question. What does an insurance policy exist to do? And most specifically, what is an HO3 policy? What is the purpose of owning that policy? And I would like a legal answer on that.
Sure. It's to cover a loss from a fortuitous event that causes direct and accidental damage to your property. It's there to, it's not a warranty. It's not there if somebody goofs something up. If you have something that is unforeseen, that is the type of thing that you would be thinking about when you should be going on and helping your family or going to work and doing things with your life to advance your loved ones and your household, then those are the types of things that the insurance policy is there to cover. They'll stand behind you for a price. It's the best money you'll never get back if you don't have to use it, but they're going to cover you and be a good neighbor, or you'll be in good hands and all those things that they say.
They're on your side.
If you do,
they know a thing or two.
They're on your side. Oh, sure they are. So,
I'm gonna use hyperbole to make a point, if you will. Okay. So a windstorm blows through. Maybe there's not any rain. There's not anything else, but wind, we all know, is a covered peril. Correct.
Yep.
It's a covered peril on the vast majority of HO3 policies. The only place where I know wind isn't covered in an HO3 policy would be like in coastal regions. Texas, for example, has something called the Texas Wind Insurance Agency, underwritten by the government, much like a flood policy would be. You're issued this policy for the specific peril of wind. And the idea is that it covers you during hurricanes. It's so that insurance carriers can mitigate the risk, because they don't want to cover that risk, because it's not a matter of if, it's only a matter of when. So I asked this question. And so I'm disqualifying those situations. Wind is typically a covered peril within an HO3 policy. You have a windstorm that comes through, rain or no rain, don't really care. Because if you've been to Lubbock, you know that the wind can blow like crazy up there, or Oklahoma or anything like that. But let's say it flips up just one shingle tab, one little shingle tab, it flips that tab up. And there is minimal damage, if any, to that shingle tab. And the carrier is going to want to say, well, that shingle is not really damaged because it'll reseal across the adhesive strip will reseal. So my public adjuster brain kicks in at this point, and I go, well, wait a minute. How many times will it have to go through that before it doesn't reseal anymore? He goes, well, most shingles will reseal 15 or 20 times. I said, except for this shingle, because it'll only reseal 14 or 19 times. And so now we're no longer at a point of indemnity. This is a loss. This loss is going to cause, additional damage. And, it's going, in order to actually indemnify this loss, it's going to involve the entire system of what's going on. And so what I often see is I actually stood in a room with an adjuster from a carrier that said wet drywall gets stronger. In fact, that's how they get wet. Drywall can get wet. That's how they do all those really curved arches and things like that. And that's how they get these curved walls, is because they wet the drywall down. What they don't tell you is that it's a double layer of drywall. One is very dry on the other side. Anyway, the methodology is immaterial at this point. But my question is even though a piece of drywall or a shingle may recover from a single event, how many less events now will it sustain? And so I believe that in a place that is a lack of indemnity for what you bought the policy for. Am I wrong about that?
No, I would agree with you. I mean, the fact of the matter is they have lessened that element of the home or the structure, because now it's more susceptible. By the way, when they talk about damage, a lot of, even Hague loves to define things based on, sacrificing service life. And what you've really described right there is a sacrifice of the service life of that element of the construction. So yeah, I mean, the losses, many of the losses we see, matter of fact, it's manifest is, it may not pick up the roof and pitch it down the highway, but what it will do is greatly damage the ability of the individual members of that roof to function. And whenever you lessen that ability, you've suffered a loss. And I really do think that your example is an excellent illustration of that at work.
Yeah, because it may withstand 15 to 20 of these events. Well, the idea is that if it's a covered loss, I should be taken back to the point of before that loss, I had 15 to 20 events. And so I want that many events back, because something may come through where a shingle needs to be pulled up and put that back down, because I don't know, maybe you're putting Christmas lights on your house and you need to move a shingle. Do you see what I'm saying?
I do, but also let's think about the real world implications of this. If you only have a certain number of exposures to a certain condition before it fails completely, then it certainly gives the insurance company the opportunity to say, well, we know it takes a lot of different, exposures to get to this point. So by definition, it has to be a pre-existing situation because it required 14 previous exposures. You see what I'm saying?
Yeah.
So yeah, I mean, if you have, put it this way, you don't have to have rain or hail actually knock a hole through your car hood before you get paid to take the dents out to get it back the way it was.
Right.
So could you imagine that? Well, you could probably have this thing look like Swiss cheese and you could still function. So we're not going to pay for it. No, that's not the product you bought. And that wasn't the premium you paid at the time the product was in the best condition or the condition that they saw it in. So yeah, your point's well taken.
Well, I mean, because people purchase it because of the ignorance level. And I use that in the true sense of the term. It's just our ability to understand what we're buying, and look, it's not just insurance policies. When's the last time anyone read their cell phone contract?
Or how about their cable contract?
Or their cable contract?
Yeah.
I mean, I don't even read my pest control contract most of the time,
Right.
and so, and it's like, so this is something that exists. It's prevalent across many different platforms, and it's not just in the insurance world. It's just here where we appear to have so many disputes because it's the activation of the contract that comes into play. I mean, as far as we're concerned, as long as our phone rings and can send and receive text messages, and it can and we can make phone calls, we're okay. And we believe that they have upheld their end of the contract because this device works. You know what I mean? So long as this device works and I have internet access and I have the things that I believe I'm supposed to have, then I'm a happy person. Because that's what I bought when I walked into the store and I bought a cell phone. Those are the expectations that I have of this. Now you take an insurance policy and our expectations as a consumer are all over the boards. You know what I'm saying? What are our expectations? There are plenty of people that think when my air conditioner goes out, my policy would cover that. And it doesn't. It depends on why it went out. If it was just mechanical failure and it was old, that's not a covered loss. Whereas if my cell phone fails, I've got some questions that I'd like to ask. Those sorts of things. And we buy this insurance, one, because we're required to. That's always interesting. We're required to purchase it. And so we don't really get into what is it that I bought? And so one of the things that I seek to do is educate consumers on what it is that you've actually purchased and what it covers. I mean, there's coverage out there for identity theft. I don't know how many people know that their homeowners policy has identity theft coverage in it.
Sure. I mean, let's just talk about, for example, the Lloyd's market, the Lloyd's of London. I mean, those are script policies that can cover anything and everything. We don't have to go to that extent with it, but it's just about knowing what you purchased under different, what I always call them, coverage buckets, because there are varying different shapes and sizes, and
right.
They don't even apply in all situations, but you need to know what they are, because those are really the tools in your tool belt when you're trying to make a claim. Here, I have this coverage for this. I have this amount of coverage for this. I have this amount of coverage for this. And, there's a lot of tricks you see with carriers. They love to overflow the bucket. Heck, if you've got 100,000 in damage and they can put it all in a bucket where you only had 10 in coverage, they don't mind that 90,000 that just spilt out your pockets. We're sorry about your bad luck. You only had 10 in coverage on your coverage C. But that's the way they play the game, unfortunately.
Let me ask you something. One of the things, and I'm going to say that what caused this, or why this business practice has become more of the standard, is where the carrier sends out third-party vendors to assess claims.
Mm-hmm.
Okay. There are, and I'm going to use a category and not a name, like what we used to use ladder assist for. So when I was an independent adjuster and I was handling claims for the carrier, if you got into one of those roofs that were just absolutely ridiculous, or you had an access issue where you couldn't get to it, nobody carries a 70-foot ladder around, whatever the case may be, we would call these third-party vendors to come out and aid us with the access, or even they would have the rope and harness equipment to access some of these more difficult roof pitches. And they would come out and they would give us an assessment. Now, I can tell you as an IA, I was never really impressed with their work. And I have become even less impressed as a PA, because the carrier is sending out people, to be quite honest with you, most of them are not operating under their license. Now, whether they are licensed or not, are they the adjuster of record? And what would you say in situations where the claim has clearly been investigated, one, by someone who is not licensed, and two, or their license is not an active part of what's going on, meaning that if something came down to litigation, or if there was some wrongdoing or an error or an omission, they're completely exonerated and out of the picture, and they don't have to answer any questions. how is it that carriers appear to be getting away with this?
Well, they definitely have to be held accountable for who they deputize as an extension of their own, claims department. If they want to have ladder assist out there, or if they want to have a TPA such as a York or Crawford and Company, any of the ones that you see, the usual suspects, then they're absolutely held accountable for the decisions and the conclusions and the work that is done by those third-party entities and individuals. When I hear about this, my trial lawyer hat goes on immediately, because one of the first things I do is, you define the scope of the conduct we're talking about for the jury. And when they try to say that they're independent, I used to always love, the first set of questions I'd have was, give them a copy of their business card that says independent and ask them if it's proper for them to misrepresent that to a policy holder, because you're independent. Webster defines that as separate and apart from, you're autonomous from this other group, yet you're out there wearing an insurance carrier's hat with an insurance carrier's patch, with an insurance carrier's pin, big clipboard with the insurance carrier's documentation on it. It's going to go back to the insurance carrier. Insurance carrier is going to make the coverage on it, or make the determination on it. If you have to change your opinion, it's because the carrier decided that they didn't like it, or they wanted to get somebody different.
I've been required to change my opinion many times.
That's right. That's right. So yes, that absolutely has to be, it has to inure to the benefit or detriment of the carrier. Now, when 542A went into effect, this is what I got a kick out of, was 542A was designed to keep, one of the things it was designed to do was to keep plaintiffs' lawyers from cleverly drafting their pleadings to keep matters in state court by having a diverse party, usually being the resident adjuster from the state they're suing in, to keep it out of federal court, because you didn't have diversity between the different parties. So they said, insurance company can elect to adopt that conduct, and then it basically just becomes part of their entity. So if they're from another state, then you just lost your local anchor to keep it within. But so here all of a sudden they can actually benefit from what they've tried to keep away for so long, which is the conduct of the third party adjuster, or the would-be independent adjuster, reportedly, allegedly.
Right. Well, I mean, it is a point of frustration with a lot of people, because one of the things that I am instructing my referral partners or contractors to do is, like, if they send out a third party and they are absolutely a third party, then you use them as your communication device, control the narrative. And that's always my big, it's like, you go show them the damage that you're wanting to claim. And legally, this is, as I understand it, and you correct me if I'm wrong, they can document the damage that you're claiming. They can take a picture of it, but for them to make a decision on whether it's covered or not covered, or really even a decision on what the causation would be. So they don't really have any right to determine causation. What they can do is document the damage that you're claiming. And when they get outside of that scope is where error comes in. Am I wrong about that?
No, I mean, what they're really supposed to do is to be the eyes and ears. They're what you call the boots on the ground, the first responder from the carrier side, and they're there to do fact gathering. And it's funny, I depose them all the time, and they run from the notion that they made any independent decision, right? They're just saying, listen, my job is just the facts, ma'am. And then I take it back, I deliver that set of facts to the carrier, and based upon what I've given them, whether it's photos, measurements, observations, whatever, they use that to draw the legal opinions and conclusions that comprise the either reservation of rights or coverage determination or the denial letter, whatever it is based on the facts gathered, observations made, pictures taken, those things that happen whenever the TPA goes out to an actual law site.
Well, you used a phrase, reservation of rights, and I just want to make sure everybody understands what that is. Would you explain to everyone kind of what a reservation of rights is and how it affects a claim?
Yeah, when an insurance company gets a claim, gets notified of a claim, then as we talked about deadlines before, they have to start the process of claims investigation. Okay. So they've got to accept or reject the claim. They like, let's say they reject it because they're like, whoa, wait, you made a claim for this policy. We didn't have a policy with you in the last 3 years, and you're making a claim here. We're rejecting this claim. It's not even within the right policy period. Or, hey, look, you've got 4 properties, but this is for a 5th one that isn't even covered. We're rejecting the claim. Either you've got coverage somewhere else or you don't have coverage at all, and you've got an issue with your agent. Now, having said that, once they make a determination that they're going to accept a claim, then they take a look at the claim and they send something out that they don't have to, but it's called reservation of rights letter. Here's what it means. It means reservation of rights. We, the carrier, we are reserving our right to deny or limit or in any way affect the coverage that applies based on what we find out. We are not right now denying your claim, but understand that we're going through the process to make our determination, and we reserve our right to possibly deny it or limit it, truncate the coverage that applies in any way, because we don't have enough to know what exclusions may apply down the road. So we're reserving our right now. It's not a denial, but yet at the same time, it's also not a wholesale acceptance of something that we haven't run aground with our investigative process.
Okay, so that makes a lot of sense. That makes a lot of sense, because in situations where I would see a reservation of rights properly executed would be in a situation where this kind of looks like fraud. This kind of looks like, arson, or this looks like somebody deliberately damaged their own roof or something along those lines. And we're going to investigate this further. So while right now we're going to go through the processes of investigating this claim, we reserve our rights to affect where it may not be covered. So that's kind of
what it does is it basically says we have more work to do, and we're going to go ahead. We're not denying you. We're going to be looking at this, but don't take the fact that we're continuing an investigation as an acceptance of the claim. We don't know if we're going to do that or not, but under the law, we're letting you know that that's the point of the process we're at right now. Okay.
Awesome. That's good. That's good to know. And so if they don't send that out, one could assume that they're not involved necessarily in that investigation. And it appears to them up to this point, because we've got no reservation of rights, that this should be a covered loss. Or am I reaching there?
No. You're right. Because what they're saying is essentially be on notice that the jury's still out.
Okay.
We haven't made our final decision yet. We're going to be doing so within the time frame dictated by the applicable law within the state they know that they're in, and that's just part of the process. You don't always get a reservation rights letter. Sometimes you just get a flat denial, or sometimes they say, sometimes you get an invocation of appraisal. Hey, we know we're not saying it's not covered. We're just saying we have a dispute on scope and damages here. So we need to go ahead and get the appraisers out there and maybe appoint an umpire who can make sense of all this and attach a number to the actual damage from this event. And that happens too.
Well, this is all just absolutely incredible information that you've provided us. And I really and honestly can't wait till we sit down and get to do this again. But before we leave, I want to make sure that everybody, so you'll be able to get his we're going to put his contact information up on the screen for you guys. If you are struggling with something, I work with Scott closely on multiple cases, and I can tell you that he absolutely is he's easy to get a hold of. He answers my calls. If he can't answer my call, he always answers my text. He's available. He is an incredible wealth of knowledge and a resource. I encourage you, if you are not working with an attorney right now, then please get in contact with Scott, because he is going to be outstanding and he's going to work hard for you. And obviously he can help you even if it's not ready for litigation. He can certainly give you some next steps and some ways to go about things. But Scott, before I let you go, and this is kind of putting you on the spot, and I know I'm catching you flat-footed here, but give us something that kind of looked like it was give us a story. I don't care how far back you go, that looked like kind of an impossible case. And it turned out to be a victory for the policyholder.
Oh, so you're wanting one of those situations where, gosh, at the beginning, you didn't even know if you wanted to take it.
Right.
You did. A lot of those relate, you gave that example before about suspicions by a carrier that a person caused their own fire or own damage. And obviously, I'm not going to get into the names of who it was, even
Obviously.
though technically once it's filed, it's public record. But it was years ago. I don't really remember, but there was one. And obviously, when we look at a case, when we evaluate a case, we front all expenses at our firm. So we have to be honest with ourselves about whether this is a winnable case. And this, I remember there was one where I remember just thinking, boy, I really, maybe he did do it. I mean, it was one of those where all the arrows pointed in that direction, but there was just some.
Come on, man, you did it, didn't you? You
did. Yeah, we ended up. Yeah, it was like, yeah, but he didn't. And there were, every now and then you just have somebody that's sort of been in some precarious situations in their past, but they've just got a good claim. And it turned out that there wasn't one thing wrong with that claim, and it was related to a fire. It was a residential property, and at the end of the day, we were able to get it collected. But I remember that was just one of those. It wasn't so much the practical difficulties of the case. It was just an incredible difference between what I thought when I started versus the evolution and the changes of how the facts played out, and how I felt about, frankly, not just the client, but the circumstances of the loss by the time we got to the settlement of the case. Right.
Well, I mean, we all get in this. I mean, the hardest thing for me, and I'm going to tell you this, is when I feel like that there is a moral victory to be won. And so sometimes I get a little clouded by my own anger or righteous indignation of something that I believe should have been done. And so a lot of what I do, I feel like, is set out to right wrongs. Just to be honest with you, is to protect the innocent and to defend the defenseless. And that's why I do what I do. And I'm with you. Sometimes there's just cases and it's sort of like, I'm sorry, there's just nothing I can do for you here. But I've done that. I've taken cases like that. And I remember I'd have never dreamed it would have happened. It was on a flat roof. It was on a flat roof situation. It was a residential claim. It was on a flat roof. And the homeowner got a bid from a roofer that said that he could fix it for $16,000.
Okay.
And what it was a resurfacing of his flat modified bitumen roof. And this file still haunts me. I still wake up in cold sweats at night dealing with this thing. And I fought against the deal. We end up winning it. I think it ended up settling somewhere around $170,000 to get the roof handled. But sure, the big thing is that the homeowner, the policyholder, turned in a bid for $16,500. The carrier wiped away what they believed the damage was and took the bid of the $16,500 and said he could get it done for $16,500. We further argued, because I handled this particularly in appraisal. I further argued it's like just because that he did that unwittingly and unknowingly, because he hired a bad contractor that gave him a basement bargain price. Your job as a carrier is to indemnify this. And they finally said, we agree with you, but we think it's only $30,000. I said, okay, then that's when we went to appraisal. We ended up winning the $170,000, right around $170,000 on that argument alone. But those are difficult ones. And I was like, you did what? You sent them what?
Yeah.
And that's why I believe representation during a very complicated process is absolutely needed. I'm not necessarily in the business of giving free advice. Not every claim is a winner. Not every claim warrants my involvement. But I would encourage everyone, and I hope you can back me up on this, Scott, but I would encourage everyone, if you're involved in a process that you don't understand, please get help.
Well, and the thing is, yeah, the claim you saved could be your own, right? I mean, in these situations, so many people, they think they have a general grasp of insurance that, oh, okay, if I have a loss, but they don't realize about the conditions, the responsibilities, of the duties, that apply. Yep. Or maybe they think they have coverage and they just logically think because I've covered my roof over my head, everything underneath it's also covered. Not the case. And certainly not the case regarding the amount of coverage. But
right.
You said something else, and I feel like I should follow up on it. Okay.
Okay.
What I've always, you can find a million lawyers out there that are happy to take a case early on and attach their fee to a lot of the money that you could have gotten without them. I'm just being honest. There are so many claims out there that could have had an undisputed payment made at the beginning, but a lawyer was involved. So let's say that claim for $100,000, they start out by, immediately paying 40 that they would have paid before a lawyer was involved anyway. But a lawyer's involved, so they're taking a third of it, or 40%, 30%, whatever their percentage is, taking away from the amount that would have automatically gone to the client. My advice and what I tell people when they call me, which is daily, is you can ask a lawyer for advice. You can ask for a point in the right direction. But when it comes to hiring a contingency fee lawyer, right? You want to hire them when your only other option is to get 100% of nothing. Because if there's still something there you can get on your own, maybe you could go through appraisal, or you could do it with a public adjuster. Maybe you don't need, but there are hallmarks of situations where, let's say they've already assigned an SIU unit because they're going to go after the policyholder for improper conduct on their end, or some sort of violation of a duty to cooperate, or a violation of the duties of the insured, things like that. Then you can go straight to a lawyer. I've had a lot of cases where they came straight to me very early on, and they just were frantic that, man, they're wanting to do an EUO, which is as examination under oath, and they were scared of what's going to happen. Are they trying to trick me? I mean, those are situations that are a little more exotic, where you can get somebody involved. But I always say, and you said it very transparently, very candidly, hey, I'm a PA, and I'm Jeremy, I'm a PA, but you don't need me necessarily in every circumstance. Same way with lawyers. And here's the addition to that. Maybe even in cases where you do need them, you may not need them as early in the process as you believe. But it's always good to reach out. I talk to people constantly. I had a guy tell me before I walked in here, he called me because he had a question about his claim, and he hadn't even got a decision back yet. He just wanted to know, hey, should I, essentially lawyer up now? No. I mean, the thing is, right now, you're in a situation where they're still determining. They may very well pay you. He had a good claim. This does right now. You don't need to be giving away a portion of your money. And I know some lawyers will do a sliding scale. That's fine. I mean, maybe you say, listen, if it, before litigation, it'll be a different percentage, something like that. But as a general rule, you always want to go through the process and collect as much of the policy as you can that's warranted under the circumstances before you reach out to a lawyer who's going to have a fee that's going to attach. Or maybe you want to pay the lawyer hourly. But me personally, I am not, if I have to work for the cupcake, I'm not in it to try to steal their icing. I mean, my whole thing is, if they need me and it's a circumstance that warrants it, I'm always there, but not until that point.
Scott, thank you so much for your time. I really appreciate all of the information that you've given us. We've got his contact information below. Guys, if you like what you've read, I'm sure we're going to be doing some other installments of Law and Policy. special claims unit. We're going to be, we'll talk with Scott some more in the future. Please leave your comments below. If you've got any questions that you would like to ask, we'll certainly get those over to Scott. And we'll let you know the next time we come through. Again, if you like what you're seeing, please press subscribe. And I'd love to hear from you. Again, if you have any questions, hit me up on social media. My number is here as well. Again, guys, thank you so much for listening. Scott, again, thank you so much. And we will talk to you guys soon. We appreciate your time.
Thank you, Jeremy.
Safe sex, that's what American style. Base sex, fuck it up like you're my pal. Go check out one and who loves you, baby. Once again, I'll tell you, it's a Roman orgy, see?